from Ohio, Mr. Latta, for 5 minutes.
Well, thank you very much, Mr. Chairman, and thanks very much for being here today. I tell you, sitting through these hearings, I've come to the conclusion if I was teaching federal administrative law in law school, I'd have the perfect case study to do. And also, having been a county commissioner back in the state of Ohio, where we actually had rules and regulations that we had to follow, this is amazing. And I know that Chairman Barton had expressed that in the last hearing, and I'm just astounded what I've been hearing today. And also, when I read the report, because I make lots of tabs and everything else. But if I could, the question is, you said it's the prerogative of the chair who gets the information. But, first of all, doesn't this board sit as a quasi-judicial board, Mr. Bell? Would it sit as a quasi-judicial board?
A quasi-judicial board?
Right. When it's making its rulings? And that it has to hear from all the parties and have to have the information come before the board?
I think the commission as a whole has to make a decision.
Right,
on
but the
anything
board makes a decision, but as it's quasi-judicial as it's doing this?
Yes,
Okay.
I'll agree with that.
And would you also say that the board needs to make, the commission needs to make timely actions on their actions when they have something come before it? Because if you don't, that justice delayed is justice denied in these cases? Would that be a fair statement?
Well, you think that within a certain time frame, after anything has happened, that you'd have motions going forward to end whatever it is you're in the process of doing.
Yes, and also following along then, when the commission's own internal procedures say a commissioner should vote within 10 business days and parties are waiting for the outcome, isn't holding a vote open for 10 months unfair in that situation?
Well, it seems unfair, but there's no, I mean, the voting process is very lax.
Okay.
And it's not enforced the way it should be.
And I found your report very, very interesting, because on page 36, when you're talking about the chairman told the OIG he did not recall the email from his chief of staff advising him not to request an extension to vote, and that he did not realize that an extension was required on adjudicatory matters if a vote was not cast within 10 days. He said that the commission does not always act in accordance with procedures. For example, the procedures say that the commission votes on matters within 10 days. But then he goes on, he said that the commission procedures are a guideline and not absolute rules, which takes us back to what's being said here earlier. Going back to the reorganization plan in Section 1, Section 2, it really lays out what the boards or the commission is supposed to be doing. Did the commission act the way it should have been acting under its own rules and regulations?
No.
Okay. Going on page 29, again, this report is just fascinating. Page 29, when you were interviewing Commissioner Osendorf, talking about what was going on July 11, 2010, it says the general counsel, the attorney, told Commissioner Osendorf that it was his experience that there were certain issues the chairman does not want to hear from him on. He goes on to say that the conversation left him with the impression that there was possibly not an open environment for OGC to provide unfiltered advice to the chairman without fear of retribution. Is that the way that we have due process being carried out in one of our administrative boards or commissions here? Does that going back to the whole idea of due process and getting something done, did that occur with this under the policy of the commission?
No, that's what we were told. This is what Commissioner Osendorf said, that the general counsel told him. So again,
Okay, because, and again, in your opening statement, intriguing. Page 7, again, in your opening statement, it's very interesting in the first full paragraph, when you said in the second line, OIG also found that although the chairman had authority to direct staff to follow the FY 2011 budget guideline, he was not forthcoming with other commissioners about his intent to stop work on the SCR as part of implementing those closeout activities. So again, is that proper procedure under the law and under what they have as their rules and regulations at the NRC?
No.
Okay, and just real briefly, you know, when you're saying not forthcoming, and we've heard the term by one of my fellow colleagues up here is talking about being misled. You know, are we talking about a word that we should be, is it a lie to mislead? Is it a lie to not be forthcoming? Or are we just talking about what some people like to talk about back home when, you know, or that they call it a lie back home, but here we're talking about a white lie?
Not for a characterization as to a white lie or an outright, it was clear that the commissioners that spoke with the agents conveyed the fact that they did not have all the information to believe that that SER was going to be stopped as a part of that budget guidance memorandum. That is factually what we were told by each of those commissioners that we interviewed. Now, the characterization as to his intentions behind it, his mens rea or thoughts about it, we didn't get into that, quite frankly, with regard to what we were trying to do was line up what occurred when and how did this document get out without their concurrence, if you would. And that's what they told us, is that they had no knowledge that the SER was going to be stopped.
Thank you. Mr. Chairman, I see my time has expired and I yield back.